Welcome to the Centre for Criminal Law at UCL, albeit virtually on this occasion. My name's David-Ormerod. I'm the director of the centre and I'll be chairing the panel this evening. There are some advantages in our being virtual. It does mean that we can accommodate a great many people. Over 250, I think, have signed up for the event this evening. It also means that we're able to organise the event very swiftly. So within weeks of the decision in Lawrance being handed down, we've secured a panel of speakers with really unrivaled expertise in this area. Before I introduce them, can I just say a few words about the process this evening? Other than the speakers on the panel, everyone will have their microphones muted and their cameras turned off. There will be an opportunity to pose questions using the Q&A facility, and I'm sure that after months in lockdown, everybody has gained familiarity with that. Each of the panelists will speak for about 10 minutes, and all of the speakers will be using slides. Those will appear on your screens, but they'll also be shared with you immediately after the event. So there's no need to feel that you have to transcribe what's appearing on the screen. There may be some scope for questions between speakers if the question relates to a particular point made by a panelist, but we've allocated plenty of time at the end of the presentations for open discussion and questions. And finally, by way of housekeeping, if the fire alarm goes off on this occasion, it's your problem, nothing to do with us. So I hope all that's clear. Let me turn then to introduce the speakers. I'm going to introduce all of the speakers and explain the order of events. First of all, we will hear from His Honour Peter Rook, Queen's Counsel, a retired senior circuit judge from the Old Bailey, formerly a chairman of the Criminal Bar Association and of my chambers. He was the course director for the Serious Sex course for the judiciary, and of course the author of Rook and Ward, co-author of Rook and Ward on sexual offences, and a new edition is promised next year. He's currently the vice chair of the parole board. Peter will start off by setting the scene for us with an examination of the decision in Lawrance, its context, and I'm sure he won't be able to contain himself. There will be some discussion of its implications. Peter will be followed by Rachel Clement-Tolley from Trinity Hall, Cambridge. Rachel's DPhil thesis was entitled Deception, Mistake, Privacy and Consent, Conceptual Framework for Resolving the Line Drawing Problem in Sex by Deception and Mistaken Sex. Thank you very much, Rachel. Very prescient of you to devote an entire DPhil to tonight's topic. And Rachel will offer her critical reflections on Lawrance, exploring the approach the courts have taken since the 2003 Act to this deception consent issue. Rachel will be followed by my colleague mark-dsouza, who will deliver the third presentation. Many of you will have downloaded or read online his two-part blog on the website, in which he proposes an innovative approach to the problem. He's seeking to argue that we can, at common law, create a principled distinction between different factors about which a complainant has been deceived. Our penultimate panelist is Nigel Gibbs, who heads up the appeals unit at the Crown Prosecution Service. His team has to make those hard choices about which cases to appeal, and in doing so to predict the Court of Appeal's likely approach. So he'll be enlightening us on the challenges in prosecuting and about the impacts the decision in Lawrance might have on charging and appeals. And finally, Professor Rebecca Williams from Pembroke College, Oxford, will offer some suggestions for reform beyond the common law. What should and could primary legislation offer on this issue of deception and consent to sex? And Rebecca draws some really interesting analogies with economic autonomy. So without more ado, I'm going to hand over the centre stage to Peter Rook, who will introduce the decision itself and some of its implications.
Well, greetings from rural France. I'm just the warm-up act whilst certain distinguished academics sharpen their knives, I suspect. I'm, as David says, going to set the scene, give the context, and deal briefly with Lawrance itself. I'm afraid that I'm going to be, well, there's always one. I'm going to be saying next, and Lisa will then go to the next slide. So if we can go to my first slide, please. You're all familiar with the first statutory definition of consent in section 74. I need say no more about that. Of course, the problem was that the 2003 Act repealed the old deception offence under section 3 of the 56 Act, and it failed to address the issue of the impact of express or implied deceptions upon consent, apart from the very limited circumstances under section 76, the irrebuttable presumptions. So next slide, please. I only expect you to read that. You're probably familiar with it and give it a wry smile, given where we are now. Next slide, please. And so, context. Well, we really have no guiding principle, or we had no guiding principle. Section 74, of course, has been widely interpreted in other spheres of activity. I've given you a case there where it certainly went to areas where it probably wasn't expected to go in respect of the impact of grooming upon the young and vulnerable. And we had no guiding principle until Monica, only some general parameters. The idea that any deceptions that fell short of section 76, the irrebuttable presumptions, vitiates consent, has been swept away, of course, by Assange. And it had become clear that the but-for test was not sufficient. But otherwise, we weren't clear about the parameters. Next, please. So here we have Assange, which made it very clear that just because deception didn't fall within section 76, this did not preclude reliance upon section 74. Choice is crucial to the issue of consent, and so deceit by Mr. Assange as to whether he was using a condom or one that was damaged was capable of vitiating consent. That was closely followed by F. Consent can be vitiated by a promise to withdraw before ejaculation. And then McNally, which I think has kept a lot of academics in business, deception as to gender sufficient to vitiate consent, but it must be an active deception. Next slide, please. And so we come to Monica, state-sponsored deception, because this, of course, involves Mr. Boyling's role as an undercover officer, forming a relationship with a woman who there can be no doubt would not have consented to forming a relationship with him if she'd known the reality. And the divisional court came up with, at last, a guiding principle, a deception closely associated with the nature or purpose of the sexual act because it relates to the sexual intercourse rather than the broad circumstances around it, be capable of negating the complainant's free choice, exercise of choice under section 74. So somehow they navigated a way where you had on one side Assange and F and the case in respect of gender deception and the others falling on the other side. It was described as just a modest change in the law as far as section 74 being, certainly nothing more than that. And so it seemed that maybe we had some sort of guidance there in Monica, but I suppose we could have detected the direction of travel. And of course, we've now had that confirmed in Lawrance. Next slide, please. You're all familiar with the facts. The appellant met a woman on a dating site. They had a sexually charged conversation. He indicated he had the SNP. The prosecution case was that, in fact, also before they had sexual intercourse, she had sought an assurance that he'd had a vasectomy. He gave that assurance. She asked for it because she didn't want to take the risk of pregnancy. And they then had sex twice, leading to 2 charges of rape. Next day, he revealed he was fertile. Perhaps one other fact I should have mentioned is that she then had to go through the trauma of a termination. Next slide, please. And so you had the arguments on both sides. As far as the prosecution was concerned, they followed Assange, argued that the consent had been vitiated by the appellant's deception as to fertility, and that was so closely connected to the act of sexual intercourse to be capable of negating agreement. After all, one of the fundamental purposes of sexual intercourse is procreation. The defense said, oh no, Assange and F could be distinguished. Consent had been obtained on the basis that ejaculate would be, in those cases, would be prevented from entering the complainant's vagina, whereas that was not the case in the facts of Lawrance. And thus, the deceit simply went to the consequences, that is the risk of pregnancy, and it wasn't sufficiently connected with the sexual act, and that the complainant had consented to every aspect of the physical act, the court said. Next slide, please. And so the conclusion of Lawrance, the but-for test on its own can never be sufficient. What they did was apply the test that the Lord Chief Justice and Mr. Justice Jay had come up with in Monaca, but then they added, is it closely connected to the performance of the sexual act? And they distinguished Assange, F, and McNally. They argued on that basis the complainant had not been deprived by the appellant's lie of freedom to choose. Is that really right? Next slide, please. Just quickly on deceptions, there had been an issue as to whether a deception had to be express or not. The HIV case had established that a failure to disclose HIV didn't vitiate consent. Assange had left open whether an express deception as to HIV status might negate consent. Lawrence said, no, there's no difference whether the deception was express or implied. They talked about the slippery slope of deception. In any event, the test is the same. Next slide, please. And the Lord Chief Justice and Lawrence referred to Lord Justice Latham's words in the HIV case, that this matter requires debate as a matter of social and public policy. And I think we'd all agree with that. Next slide, please. Now, I'm not going to sit on the fence here. If I had been a judge at first instance, I would have ruled the same as Mr. Justice Baker. And indeed, I have to admit, just about every judge I've spoken to about this since. But opinion is divided. Many regard the vasectomy and the condom restriction as wholly artificial. And the point is made, well, the exposure to the risks of pregnancy are surely fundamental to a woman's integrity and so to a woman's right to choose. She'd had to undergo the trauma of termination, the very thing that she'd sought to avert by making inquiries. There'd been a violation of her physical integrity. And many would have given a wider meaning to both nature and purpose. And I'm not just talking about judges. Do we have a guiding principle now? Well, I suppose so, and you could argue some greater clarity, but at what cost? And are the public going to find this distinction at all clear and easy to follow? Next and last slide, please. So, well, I don't know whether Nigel's going to reveal tonight, perhaps not. Are they going to argue there's a public of importance here? If it went up to the Supreme Court, I suppose they could even lose the Assange point. We certainly need to have a fresh look here, something for the Law Commission maybe. But the worrying thing is surely that there's culpable conduct here that should be within the scope of criminal sanction. Something observed by Professor Spencer in the article to which I refer there. Of course, we lost that section 3 of the 1956 offence. I think the Law Commission came up with the idea of a deception offence in 1995. And indeed, there's been other support for it. Well, if we are going to make section 74 so weak, as appears to be the case at the moment, then it seems to me that there is a strong case for a deception offence. Maybe the reason why the 2003 Act repealed the deception offence was because it was felt that the offence of rape should not be diluted. Well, now it appears to be diluted. Has the time now come? Thank you.
Thank you, Peter. You've already answered the one question that I was going to ask, which was, would you have decided the case in the same way? Just to ask you a supplementary question, which flows on from questions really from Vincent Scully, who's barrister at 6 KBW College Hill. Do you think that Assange would be upheld in the future? He describes this case as having paid lip service to Assange. Do you think that the Crown would lose Assange if it did go to the Supreme Court?
I think there's a real risk that they might. I can see them finding the distinction between Assange and Lawrance very artificial. And if they imposed a restrictive interpretation, then of course there is that very risk. That would make the case even more powerful for the deception offence, of course.
Okay, we'll come back to that, I'm sure. Let's move on immediately to Rachel, who, as I've said, is going to give us yet more by way of critical reflection on this case.
Thank you very much. I don't mind starting by saying that overall I tend to be of the view that the 2003 Act isn't fit for purpose in this particular context, and that in the absence of some further legislative reform, we're destined to have to live with some sub-ideal compromise position between protecting sexual autonomy, securing legal certainty and predictability, and limiting judicial overreach in light of legislation that gives us, as Peter's described, very little guidance. As far as Lawrence is concerned, I could certainly say far more about it than I could fit into 10 minutes. So I won't address the mistake-deception distinction or whether the court's application of this physical difference category to the facts of Lawrence itself is correct. I think both of these things will be touched on later on by others. So I'd just like to focus on a couple of, I think, other serious problems with the reasoning in the case before making a brief pitch for what I hope is a preferable, if still far from ideal, compromise position. And I'll start from the same assumptions which underpin much of the jurisprudence in this area. Firstly, that Section 76 doesn't cover the ground as far as deceptions and consent are concerned, but also that under Section 74, it cannot possibly be the case, it can't be a fair reading of the legislation, that all deceptions or mistakes ought to vitiate consent. The challenge then is to figure out how and where the line should be drawn in a way which is, insofar as possible, both principled and predictable. And I'll suggest that the decision in Lawrence falls short on both fronts. The problem with Lawrence in principle, or at least one problem with it, is the way in which it empties the notion of a free choice to engage in unprotected sexual activity of any meaningful content, and in this I sort of echo Peter's comments from earlier. The court, I think it's really striking, the court doesn't engage at any length with sexual autonomy, what that means, the role the right plays in underpinning the legislation. And the discussion of the statutory language of Section 74 is also incredibly limited. We get this lengthy analysis of the conceptual and physical differences between deceptions as to condom usage and withdrawal on the one hand and deceptions as to male fertility on the other. But there's scant explanation as to why these differences support the assertion made in paragraph 38 that the lie, Jason Lawrence's lie, doesn't deprive the complainant of a free choice under the terms of the statute. What we have really is an assertion without full argument. And I think this is all the more troubling given the way in which Lawrance introduces this yawning back door into the protection previously offered by Assange and F. So those decisions seemingly undergird a woman's right to exercise her positive sexual autonomy whilst controlling the risks of pregnancy and disease transmission. But of course, that protection is undermined if liability is only imposed in cases where deception relates to condom usage or withdrawal, and not in cases where the defendant's deception induces the complainant to think that there's no good reason to insist upon condom usage or withdrawal. Following Lawrance, provided a defendant can deceptively convince his partner to forego such insistence, it seems he can violate her sexual autonomy and integrity with impunity. This physical distinction, this conceptual distinction that's adopted by the court in Lawrance is elevating this kind of descriptive, very dry, artificial conceptual difference between different types of deceptions to a level of normative significance it just can't bear when we keep the right to sexual integrity or autonomy firmly in mind. Both kinds of deceptions result in egregious violations of sexual autonomy. And of course, in a context where the complainant's motivations for stipulating the deal breaker, consent, condom usage, withdrawal, fertility, risk of disease transmission, the motivation is exactly the same in all of these cases for stipulating this as a deal breaker. So it's very hard to view the reasoning in Lawrance as capable of protecting the right to sexual integrity or distinguishing between these key fact patterns on any principled basis. But perhaps, as Peter suggested, the Court of Appeal, mindful of the limitations of the legislation, regard this as a necessary price to pay, if you will, in order to secure some certainty in the law. Now, of course, this is contingent on the idea that the distinction in Lawrance is easy to draw and has been drawn in the right way on its facts. As I say, I won't dwell on these points, though I think both are open to reasonable challenge. Instead, I want to demonstrate how any claim to coherence and certainty is fatally undermined by the very shaky foundations upon which the decision is built. So one major problem is that the approach adopted in Lawrance just cannot explain McNally. Now, in McNally, the complainant knew that the defendant was penetrating her digitally. The complainant knew that the defendant was performing oral sex upon her. There's no deception related to the physical performance of the sexual act, or that the act was indeed sexual itself. And I think it's noticeable that the Lord Chief Justice in Lawrance went to great lengths to explain the distinction between the facts of Lawrance on the one hand and Assange and F on the other. But when it comes to McNally, again, we have only this bare assertion in paragraph 36 that the cases are somehow different. Now, the reasoning of McNally itself is fundamentally in conflict with the reasoning in Lawrance. Lord Justice Leveson explicitly rejected in McNally the physical difference distinction upon which Lawrance is based and upon which counsel for McNally sought to rely. Whilst I think there are serious problems with the characterization of McNally in similar cases as involving deception as to gender, for the sake of time, let's just run with that assumption and follow the logic. On what basis could that sort of deception alone possibly be thought to fall within the scope of the Lawrance rule? The only detailed explanation we have for McNally and its continued rationale in this area of the law is found in Monica. So in Monica, the court endorsed the CPS lawyer's view that McNally should be analysed as a case which is sort of akin to impersonation, so not necessarily a physical difference case at all. And of course, much of the reasoning in Lawrence is based on the decision and the reasoning in Monica. Now, the reasoning, I think, the explanation of McNally is somewhat hard to follow, but I think it goes something like this. As far as the court's concerned, the complainant identifies as heterosexual. She's actually engaging in same-sex activity with the defendant rather than opposite-sex sexual activity. The complainant's heterosexuality is central to her identity, and the centrality of her sexuality to her identity somehow transforms the defendant's deception into one which is akin to impersonation. Now that seems pretty strange to me, but as I say, let's work through its logic. because I think if we do, we'll see that the law might well be broader than the courts in Lawrance and Monica seem to realise. Now, in both Lawrance and Monica, it's made abundantly clear that deceptions as to marital status, including deception as to the validity of a marriage ceremony between the defendant and complainant themselves, fall well outside the scope of liability. But let's look again at that old Australian case, Papadimitriopoulos. Defendant knows that complainant will not consent to sexual activity outside marriage, and so orchestrates a sham wedding ceremony to induce the complainant to have sex. Could it not be argued that this deception relates to such a central aspect of the complainant's sexuality as to render the defendant's deception tantamount to spousal impersonation? If that kind of argument can be ran in McNally to explain McNally, then why does it not apply here? Because, of course, from the complainant's perspective, at least, the difference between marital and extramarital sex goes directly to her understanding of the sexual nature of the acts in which she participates. The only explanation of McNally we have left in the jurisprudence, I think, leaves the door open for precisely those cases the court in Lawrance takes such great pains to exclude. The retention of McNally and its explanation causes a whole host of problems for the law in this area, not just this, but it certainly challenges the notion that Lawrance provides a predictable, viable and workable rule going forward. So in sum, and whilst I've not given you all of my evidence for this argument, I think to suggest, I think it's fair to suggest that the current situation is neither principled nor as simple and predictable as the Court of Appeal would like to think. So might a better compromise position be found? Well, I can't hope to justify my position on this in the next minute or so, but let me sketch out where I think we could have, the position we could have reached in Lawrance. I think the court could have drawn a slightly broader set of bright lines by including both physical difference deceptions and those deceptions which result in a risk to the complainant's sexual or physical health within the scope of liability. That is, aside from the retention of McNally, broadly the position the CPS reviewing lawyer took in Monica. This would avoid enacting the sea change in the post-2003 law that the Court of Appeal was so concerned about in Lawrance, but it wouldn't empty Assange and F of much of their force. And if McNally could be distinguished and overturned in, let's say, a Supreme Court decision, then this might prove a more workable and practical dividing line than the highly arbitrary conceptual distinction we get in Lawrance. We could also justify picking out these categories as in some way rooted in the complainant's interest in controlling the risks of adverse consequences associated with sexual intercourse, or at least unprotected sexual intercourse. But of course, even this alternative compromise carries an obvious weakness. It doesn't go far enough to protect autonomy and integrity, which can be infringed in a far greater range of deception cases. And the facts of Monica are, of course, a good example of one such case where criminal liability in an ideal world should follow. But this isn't an ideal world, and the 2003 Act is far from an ideal piece of legislation. So taking seriously the limits of judicial decision-making, as I say, I think a compromise is the best we can hope for, but I hope I've gone some way to showing you why Lawrance is not the right compromise to strike. Thank you. David, I can't hear you. I think you're muted, I'm afraid.
Sorry about that. Thank you, Rachel. Obvious again that you would not have adopted the same approach as the Court of Appeal in Lawrance. Can I ask you the same question? Do you think that the Supreme Court would could produce a better outcome here by dealing with not necessarily Assange, but McNally, which you seem to be seeing as the central sticking point in resolving some of the incoherence?
I think McNally causes an enormous problem for the law. I mean, it's fairly clear that the courts want to row back from the quite broad position we had after McNally, where you see Lord Justice Leveson saying, well, you just take a common sense approach and this will help us solve the line drawing dilemma. It's very difficult to keep McNally in a way which is conceptually and conceptually sound without opening the door to the kind of cases you see in Papadimitriopoulos, to the extent that I think it's fair to say that was never the intention behind the 2003 Act, even if we think Section 74 is designed to have a broader scope of application than those deceptions which you see within Section 76. I think it would be very, very difficult for the Supreme Court to keep McNally, even if they were to, let's say, keep Assange and reverse the decision in Lawrence. And that's probably right for now, at least.
Okay, great. Let's move on with some more constructive suggestions for ways in which the common law might resolve this to Mark-dsouza.
Okay, I think I'm unmuted now. Good. Thanks so much, David, and thanks to all of you for joining. Thanks to the panelists who I didn't get to say hello to because I don't know why. But thanks to you for joining, and thanks to all of the attendees. I hope you're enjoying this discussion just as much as I've been enjoying it. And I'm not going to dilly-dally around. I'm going to get straight to the point, which is what you want to hear about, how we should be interpreting the Sexual Offences Act 2003. So let's start with some background. Now, the Home Office's 2000 report titled Setting the Boundaries, Reforming the Law on Sex Offences, which led to the passing of the 2003 Act, made it clear that the protection of sexual autonomy was central to the new law of sexual offences. And there's no reason to think that Parliament thought differently when actually passing the Act. Now, if V's sexual autonomy means that she has absolute authority to choose when to engage in sexual activity and with whom, logically, it must also mean that V has absolute authority to choose the conditions on which she will consent to sexual activity. So it's often taken to follow from this that if at the time of sexual activity, V is mistaken as to any deal breaker belief, that is to say a belief that if V knew was false, V would not have consented to the sexual activity, then legally, V did not consent to the sexual activity. But of course, that seems to generate extremely harsh results. It makes the offense of rape over-inclusive because every background white lie, every embellished fact, every half-truth that has ever nurtured a budding relationship might just vitiate V's consent to sex and expose D, subject to mens rea, to being labeled a rapist. So is it actually possible, within the words of the Sexual Offences Act 2003, to adequately protect sexual autonomy without making the law of sexual offences over-inclusive and excessively harsh? Well, like Rachel, I have my doubts about whether a perfect solution is possible within the wording of the Sexual Offences Act's drafting. But I do think we can make substantial progress. And to that end, in the blog post that David mentioned, I have tentatively suggested what I call a disjunctive approach to understanding the effects of the falseness of a belief on sexual consent. Now, I should say this idea is at a very early stage of development, and I'm very open to modifying my views based on your comments, but here's what I had in mind. Now, it's widely recognized that the process of granting sexual consent or consent to sexual activity usually involves a largely visceral rather than cerebral exercise of sexual autonomy. Now, typically, it owes more to instinct and emotion than to analysis. In layperson's terms, most decisions about having sex sound more like, well, one thing just naturally led to the next, or it just felt right, rather than I considered the pros and cons, and I concluded that my best course of action was to consent to sex with D. And actually, most exercises of sexual autonomy involve a combination of visceral and cerebral processes. And the consents that both of these processes generate are equally valid. But I think that the falseness of a belief affects sexual consent differently depending on how it was granted. And so I suggest that we adopt a disjunctive approach. We distinguish between visceral and cerebral grants of consent when adjudicating on these matters. So any exercise of sexual autonomy is made against the backdrop of a plethora of beliefs that we hold. However, for a belief to matter for sexual consent, we must exercise our sexual autonomy to make that belief relevant to it, and creating that analytical relationship between the truth of a belief and the validity of consent is a cerebral act. So we only make the truth of a belief a precondition to sexual consent or for sexual consent when we exercise our sexual autonomy cerebrally to do so. Only then will the falseness of the said belief have any effect on the resulting sexual consent. So V may advert to or make a precondition for her consent to sex with D, her belief that D is wearing a condom or intends not to ejaculate in her or has already been sterilized. If these beliefs then turn out to be false, then despite appearances to the contrary, we can say that V's consent to sexual activity never arose. And I'm sure the audience today recognizes that these examples are drawn from the facts of Assange, the Crown through F against DPP, and the Crown against Lawrance. In the first two cases, it was held that V's consent to sex would be vitiated by the falseness of the relevant belief. But in the last case, it was held that the falseness of V's belief would not vitiate consent. The disjunctive approach suggests or supports the ruling in the first two cases, but not in the third. And I think we should reject the ruling in Lawrance, not just because it falls foul of this little principle that I've been arguing for, but also because, as I explained in my blog post, the court seriously erred when applying the doctrine of precedent. It relied on Monaco, on observations in Monaco that were conditional upon a rather dubious concession made by the prosecution. It recognized that the concession made by the CPS lawyer was very generous to the applicant. And it said, well, let's assume that that concession is correct and that in fact the law of sexual offences hasn't changed post-2003. On that assumption, this is how we can make sense of the post-2003 law. But that was an assumption. It wasn't an actual finding that the law was exactly the same. And yet it's been treated in Lawrence as if it was an affirmative categorical finding that the law is exactly the same or almost essentially the same as pre-2003, and this is how you should read it. Anyway, that's in part one of that blog post. You can read it at any time. But under the disjunctive approach, my claim is that V can exercise her sexual autonomy to make the truth of any belief a precondition to her consent. So take the pre-2003 Act case of Lineker. V, a prostitute, agreed to have sex with D on the understanding that D was planning to pay her. Now, D had no such intention, yet he had sex with her. On the law as it stood then, it was held that V's consent to sex was not vitiated. But the law has changed, both in terms of the words used in defining the offence of rape and in that the protection of sexual autonomy has been made a foundational principle of the new Act. Were these facts to arise now, I think that the correct outcome would be entirely different. Respect for V's sexual autonomy means respecting her choices as to what she makes a sine qua non for her consent, regardless of what we think of the worthiness of those choices. That's the point of giving someone sexual autonomy. So if V cerebrally exercises her sexual autonomy to make the truth of her belief that, say, D shares her white supremacist views a precondition for her consent to sex, well then respecting her sexual autonomy requires us to recognize that D's consent is vitiated and that D has the mens rea for rape when D, knowing all of this, pretends to share V's views to have sex with her. And that's true no matter what we think of V's belief. Now, it will typically be easier to convince a jury that, firstly, V cerebrally exercised her sexual autonomy to make the truth of a belief a precondition for her consent, and secondly, D did not reasonably believe that V had genuinely consented, when in fact D actively deceives V into holding the false belief. But that's an observation about evidence. In principle, it doesn't matter whether V's false belief is induced by D's deception or a third party's deception or even a unilateral mistake. What vitiates V's consent on this view is the falseness of her belief, not how she came to hold that belief. Of course, whether D would be convicted is a separate matter. That depends also on D's mens rea. But whatever V believes, and this is the flip side of my argument, whatever V believes, if V did not cerebrally exercise her sexual autonomy to make her belief a precondition for consent, then its falseness has no effect on the consent's validity. D may have committed some other wrong, some other offense, but not a sexual offense. And that explains why the courts in the Crown against P and Monica respectively held that D's non-disclosure of his HIV positive status, or that he was really an undercover policeman and not a hunt saboteur, did not vitiate D's consent to sex. It's unlikely that D adverted to her background beliefs about D's sexual health, his environmental commitments, when exercising her sexual autonomy viscerally, or at least non-cerebrally with respect to these matters. So the falseness of these background beliefs will not affect the validity of V's sexual consent. And that's true, even if without these background beliefs, V would never have considered exercising her sexual autonomy in relation to sexual activity with you. So in sum, where does that leave us? I think that the disjunctive approach protects V's sexual autonomy by letting her choose to make the truth of any of her beliefs a precondition to her consent to sex. And although D's active deception as to such a belief will help in matters of proof, in principle, it doesn't matter how V came to hold that belief. Yet, this doesn't, I think, make the law of rape over-inclusive, because the falseness of the belief only affects sexual consent, where V has cerebrally exercised her sexual autonomy to make its truth a precondition for her consent. Now, as you can see on your screen, I've gone into a lot more detail about how this view would play out and what the other implications are for how the law would look like in my blog post. The implications are on your screen for a quick look. But for now, I'm just going to leave it at that. I'm happy to discuss this idea or any part of it further with you at any time during this semester. Thanks.
Mark, thank you very much. This is a very innovative approach. Can I just clarify one thing, which I think is crystal clear in the blog itself? This does place a greater burden on the complainant to articulate more clearly which of the factors have become conditions of consent. We cannot assume, even if a factor is integral to her being, possibly something like religion, that it would be fatal to consent unless it is articulated, because it requires the complainant's cerebral engagement at the time of the act of intercourse.
Thanks, David. Yes and no. So I don't think that articulation in the sense of verbalization is necessary. What I think is that you should be able to prove it in some way or the other. But articulation or stating the condition to the defendant is not necessary, because it's the falseness of the belief on this view that vitiates consent, not what the defendant did with it. It may be helpful in proving the defendant's mens rea. But in terms of whether the consent is vitiated or not, I think it is possible to say that the consent is vitiated, perhaps the defendant didn't have the mens rea. That said, no matter how closely or how central a background belief, say belief as to religion, is to the complainant, if she does not make that, cerebrally make that a condition for her consent, then I think we can draw a line and say that's background. And that's actually the law as it stands today as well. So there's an Israeli case which didn't actually go to trial because there was a plea bargain involving a person called Gashur, who allegedly pretended to be Jewish to have sex with a woman who wouldn't have had sex with him, but for her beliefs that he was Jewish. And in that case, there was the defendant pled guilty to rape by deception, which is the offense that they had there. I don't think that case would be decided the same way under Lawrance on Wanaka. And I don't think that's the way the case really ought to be decided, unless the complainant specifically said or made it clear or thought to herself at the point of time that I am consenting to sex on this condition. A lot is going to turn on how you prove these matters, of course, but I think it's a principal line that can be drawn, and it helps us get a little bit further away from Lawrence, which really, really narrows the scope of any deceptions that can vitiate consent.
Mark, thank you very much. Let's move on to yet more of the practical implications of the decision in Lawrence. Nigel Gibbs, who's going to take us through some of the challenges that the CPS face in crystal ball gazing as to what the Court of Appeal will do next, and in making effective charging decisions as well, I suspect. Nigel.
Hello, thank you, David. Welcome all, and it's a great pleasure to be able to speak to you about this complex and fascinating issue, and also what challenges there are in prosecuting these types of cases. As we've already heard, the statutory definition of consent, which is choice and the freedom and the capacity for that person to make that choice, was meant to clarify the law on consent. I do think, on the one hand, that it has done so, but in some instances, the parameters of consent under Section 74 are not clear, and especially in relation to deception. The white paper setting the boundaries had suggested an offence of obtaining sexual activity by deception. My understanding was that the government intended to introduce such an offence, but for some reason, it and Parliament didn't do so. When examining these cases for prosecution, it is the context that is critical in these cases. The first point to make is that not all deceptions negate consent. The issue is, where should the line be drawn? It's important to understand what circumstances negate consent and circumstances which do not. The court has identified certain situations in which it does negate consent and those that it does not. So in Assange, the sexual intercourse without a condom against the wishes of the partner might negate consent where there's a deliberate act to have sexual intercourse without the condom or to damage it. But it is not an offence if the condom came off accidentally or was damaged accidentally. So here the precondition was for actual penetration. In F, the essential evidence was the relationship was marred by the defendant's abusive dominance. In ejaculating without her consent, there was evidence that he deliberately ignored her wishes as a manifestation of his control over her. He deemed his wife subservient to him. But the court said that there was no evidence where D was intending to withdraw in accordance with C's wishes, ejaculates prematurely or accidentally. Again, the precondition in F was as to penetration. In McNally, as we've heard, the deception took place over many months, where the defendant deliberately deceived the victim as to the gender. The courts have also set out situations where deception does not negate consent. Reference has already been made to Lineker, where L deceived the prostitute into having sexual intercourse without the intention of paying. But he could be guilty of obtaining services dishonestly. In RVB, D was HIV positive and had unprotected sex with C, who did not know. And the court said this didn't negate consent. But again, the court said B could be guilty of assault. The courts have also indicated that a person's wealth, status, and employment does not negate consent. And likewise with Monica, impersonation by a police officer of an activist sharing the views of the complainant when she would never have consented if she'd known his true identity. And finally, in Lawrance, where the deception didn't relate to the physical performance of the sexual act, but to the risks and consequences associated with it. Consent, they said, could not be affected by whether pregnancy followed or not. The issue is, what can an unwanted pregnancy be an assault? I don't know the answer to that, but maybe there might be civil liability. So when deciding or looking at such cases for prosecution, as I've said, the context is crucial. One has to focus on the relevance of the deception as to the nature of the act. It's worth saying that there are many different ways in which sexual relationships develop, levels of understanding and tolerance, expressed or understood, and mutual give and take between parties. These are very personal issues. And on top of these relationships, there may be deceit, in which there are many forms. And as the court in Lawrance said, it may be difficult to draw clear principled lines distinguishing deceit from other conduct. There's a wide spectrum ranging from a clear express lie to communications that are obscure, evasive, confusing, or give a false impression. But how does the deception relate to the nature of the act? One has to identify what the act is. So does it relate to the performance of the sexual activity, or is it closely connected to it? Does it relate to the surrounding circumstances, as the example in Monica? Does it relate to the consequences of that activity, as in B? These are not easy issues to resolve, but in assessing them, we need to establish the facts of the case, assess the credibility of witnesses, assess the reliability of witnesses, examine the case through the eyes of all the players, including the jury, understand the motives of the personalities on all sides, and assess the likely impact on the court. In some cases, such as Lawrance, the parties were not known to each other, and there were some, although not many, communications before and after sexual activity. In other cases, there may be complex relationships lasting a long time involving abusive and coercive situations. It's noteworthy in F that the court said it was inappropriate to examine one incident of sexual intercourse in isolation. One has to look at the history of the relationship as well as what was said when sexual intercourse was taking place and the observations afterwards. If there is evidence that shows that deception negated consent, then of course the prosecution need to go that one step further to show that D did not reasonably believe that C was consenting. The nature of the deception and its circumstances may assist in determining this. Again, in F, there was an abusive and coercive relationship in which the evidence showed that D did not reasonably believe that his wife consented. So has the court drawn the line correctly? Parliament, it could be argued, left a gap in the law and courts have had to step in. In such situations, there is always a risk that decisions that are not in perfect harmony with each other or that the principles are aligned. The Court of Appeal has drawn the line so only deceptions closely connected to the performance of the physical sexual act will negate consent. One can criticise the reasoning, but I think it's right to say that this was a careful and reasoned judgment focusing on the statutory language and the relevant case law and reaching the conclusions that corresponded with both, and some might say justifiably so. It also limits extending the law, because consent relates to other offences, to include situations in which people are not regarded as criminals but may become criminals. And as the court said, gave the example, a woman who lied about her fertility where the man would not otherwise have consented to sexual intercourse would also be guilty of a sexual offence, albeit not rape. It may be that such deception should amount to a crime, but should it be rape, which carries a life sentence? This is a matter for Parliament and not the courts. So whilst Lawrence has not resolved all the issues, I do agree with Peter to some extent that it has clarified the law further and in this very difficult and complex area of law. Thank you.
Nigel, thank you very much. Can I ask you, I'm not going to ask the question that will put you on the spot by asking whether you're going to the Supreme Court, don't worry. I'm going to ask whether you think that the position from a prosecutor's point of view would be made easier if there was an offence similar to that in Section 3 of the 1956 Act, procuring sexual intercourse, procuring a sexual act by a deception by false pretences. Or would that simply complicate matters by allowing for or leading to alternate counts on every indictment?
I don't think so, because in such cases, in the case of Lawrence, for example, she consented fully to penetration and to ejaculation. There was evidence before the sexual activity that she wanted that to happen, and also afterwards. But clearly, the lie that he had said had a vasectomy went so far. But the thing is, did that or should that mean that he's guilty of rape? But because she did actually consent to the penetration and to the ejaculation, which is different to Assange and to F. So I think in such a situation where the court has set parameters, and Lawrence has done so, then I think an offence of obtaining sexual activity by deception would be the right one.
Okay, well that discussion there of precisely what it was that was consented to in Lawrence leads us nicely on to Rebecca's paper, where she's going to say that the solution lies in primary legislation, I think. Over to you, Rebecca.
Thank you very much, David, and thank you to David and Mark for inviting me to talk to you about this. So as you say, I am going to come on to talking about aligning sexual and economic autonomy in the way that they're protected by the criminal law at the moment. But just before I do that, I can't resist adding my 2 pence on Lawrence, so I'll do that first. First of all, the good thing I think about Lawrence was that the court did, as we've heard already, remove the distinction between positive deceptions, positive caveats, and failures to disclose. And I think that removal is actually very welcome. We do have a problem going forward, especially given what I'm going to say later, and we do have to think about what will count as a minimum level of deception in this sort of context. But I don't think that previous distinction had any sensible roots in the 2003 Act. I don't think it was normatively very justifiable, and it wasn't getting us any closer to the sorts of questions that we do need to address. So I think it's good from that point of view that that has gone. But what I think was problematic about the decision in Lawrence were the statements of the court at 20, that the complainant consented to every aspect of the physical act, and then again at 36, that she had consented to sexual intercourse without imposing any physical restrictions. And Peter and Nigel and various other people have taken us very helpfully through the facts of the cases of F, Assange, B, and of course Lawrence. And the point about all of those cases is that none of the women in any of those cases had in fact consented to every aspect of the physical act. All 4 of them had imposed physical restrictions on it. And if we look at the table on my next slide, then we can see what those physical restrictions are, and we can see how those cases align with each other. As I say, all the women in those cases lacked consent in relation to the presence of a particular physical entity entering their bodies. All of them, therefore, lacked consent in relation to one specific aspect of that physical act. So I really don't think there is any conceptual or normative distinction that can be drawn between Lawrence and any of those 3 other cases. As I say, I think they align the way that I have aligned them in that table. Interestingly, though, to pick up on some of what Rachel was saying earlier, if we compare McNally to those cases, then I think we do see a distinction. In McNally, the victim consented to digital penetration, but of course that was exactly what happened in McNally. It was just that the owner of the fingers in question was someone who had been assigned female at birth, not someone who had been assigned male. So actually, if we were going to distinguish any case from those 4 listed above, it would have been McNally. And yet, of course, as we know, that was not what happened in Lawrence. McNally was allowed to stand, and Lawrence was distinguished from the other 3 cases in that table. So we do need to do some reforming here. What can we do? Well, if it does go to the Supreme Court, I think there are certain things that even can be done at common law court level. So even if it remains with the courts to solve this problem, there are things that can be done. And if it does go to the Supreme Court, I would strongly urge that the court avoid such general tests as that we have from Lawrence and Monica, this test of sufficiently close connection to the performance of a sexual act. I don't think that test is clear enough to provide specific guidance to courts as they confront new fact situations. What I would strongly urge the Supreme Court to do, if it does hear this case, is instead to generate a series of coherent and clearly distinguishable categories. And I've argued elsewhere what I think those categories should be, but one of them I think should be a category of physical difference, a situation in which the victim has experienced something which is physically different from what they were anticipating and what they had consented to. And that table of 4 cases on my previous slide would be at the core of that category. But as David said, I think it might be better still, in fact, if we were to pick up on the Court of Appeal's suggestion towards the end of the judgment, that actually, and I think I already mentioned this, these issues require debate as a matter of social and public policy. And I think what we really probably need to do, again, as Rachel was saying, is to stand back and have a look at restructuring the primary legislation that's underpinning all of this altogether. So if we do that, what form should that reform take? And we've heard some discussion this afternoon about the possibility of enacting a new version of the old Section 3 1956 Act, a new offence of procuring sex by false pretences. And various people have suggested that this afternoon, and John Spencer, as Peter alluded to earlier, has also suggested that. So is that something we should do? Well, my answer to that is yes and no. So what I don't think we can do is to parachute a new version of Section 3 into the existing structure of our legislation. I don't think we can have it within and in addition to the current scheme of legislation that we have. Why not? Well, the problem is this. Why would we have such an offence? Because the victim is not consenting. Well, if the victim is not consenting, then that's an offence of rape. And if we don't think that that's the problem because we think the victim is consenting, so it wouldn't qualify as rape, then why would we want to criminalise it in the first place? And that to me is the problem, that we can't parachute a different kind of offence into our existing structure of the Sex Offences Act. And what that also does is it brings us to, I think, what is the heart of the problem here, which is that the whole problem is that consent as defined under the Sex Offences Act 03 is basically binary. It's a yes or no question. Either the victim consents or they don't, and that's it. But what I think the suggestion of a new offence of procuring by false pretences might do is I think it might help to point us to the way to a better option. If we think about it, the whole concept of fraud in English law is something that we're much more used to encountering in the context of property offences. And if we think about the structure and the area of property offences, that area actually is precisely divided up according to the method of the vitiation of consent of the victim. So for example, if the vitiation of consent was by stealth, we call it theft. If it was by force, we call it robbery. If it was by pressure, we call it blackmail, and so on. And what I've done in that table, on the right-hand side of that table, is to take some of the decided case law, both from under the 56 Act and from the 2003 Act, and show how those cases could be aligned with those property categories if that was something that we wanted to do. If we focused instead on the method of vitiation of consent, we could divide our existing case law up in the way that I've shown there. Now, of course, if we look at the historical relationship between property offences and sex offences, it's much more problematic. But if we look at the relationship between the two of them where we are now in the 21st century, then actually both areas of law are very much seeking to do the same thing. In both contexts, we have transactions or interactions, or however you want to put it, which society needs and wants to go ahead and want to facilitate those transactions. But at the same time, there are versions of those transactions or interactions which are harmful and which we want to prohibit and prevent. And in both those areas, the criminal law is performing the same role. It's trying to trace that boundary and police that boundary between what the sort of transactions that we want and the sorts of transactions that we don't want. And I think once we've aligned those two areas in that way, the question then becomes, actually, why don't we protect sexual autonomy in exactly the same comprehensive and nuanced way that we do currently protect economic autonomy? So what we could potentially do, and as Mark was saying with his proposals, this is very much a proposal, and I'm very, very keen to hear other people's views on this. I'm really looking forward to feedback on it. What I think we could do would be to replace our single offences of rape or sexual assault with a series of offences of, for example, rape by stealth, rape by force, rape by fraud, and so on. So yes, adopt an equivalent of a new section 3, but alongside a whole series of other offences which also focus on the method of vitiation of consent, just like we have in property law. Now, if we were starting to draft sex offences legislation for the very first time, we might not call them that. We might call it procuring sex by false pretences or whatever it is. But I think actually retaining the term rape within those new offences in the way that I have done in that bullet point is something which is going to be important both for victims and I suspect almost certainly to any government which is going to legislate in this area. So as I say, these are very much proposals, and I've been sort of thinking to myself, well, what might be the arguments against doing this? Why might we not want to do this? Well, one suggestion is that, of course, that doesn't necessarily immediately fit with public opinion. This may not be what people already think of rape as being, and so this might come as a bit of a shock to the public. But I think on that front, we need to remember that the criminal law can lead as well as follow. So Paul Robinson has some really interesting work in which he says, as long as the criminal law spends its credibility chips, as he puts it wisely, as long as it doesn't go running too far out in front of what public opinion expects, then the criminal law can lead as well as follow. And crucially, one of the things which he suggests is successful, if the criminal law is going to lead, one of the ingredients for success is analogizing to a core area where people do already have developed instincts. And of course, that's exactly what I'm proposing that we do. We analogize to the core of property offences where people already have those instincts developed. And as examples, he gives the context, for example, of drink driving and domestic violence, where maybe in the 1960s or 70s, we wouldn't have seen those areas as being particularly immoral or deserve criminal intervention, yet of course we don't even question that today. It's obvious that they are. For two more recent, very interesting examples of a situation where the criminal law partly follows but also partly leads, we have the two new offences which I've put on the slide, colloquially known as upskirting and revenge porn. And again, those are areas where the law is partly responding to a sort of public need, but also taking a little bit of a lead on those sorts of contexts. So that's not necessarily a deal breaker. Done properly, the criminal law can lead as well as follow, as long as it spends its credibility chips wisely. Now, another potential counter-argument is that there might be a bit of an overlap or a choice of offences problem. If you had all these different offences, how do you choose which to prosecute? And I think that is a genuine problem. I deliberately put Jeter and Bingham in more than one column on my previous slide because I think that's fair. I think they fall into more than one column. But I think actually that is the great joy of analogizing ourselves to an area that already exists, because those problems already arise in property too. We can see that in cases like Hinks or recent Barton or the other Lawrance with an E. We have the same problem of, which category should we put those in? So an advantage of bringing the two areas into line is that we can either adopt existing solutions that we already have in property offence law, or if we don't think they're suitable, we can then come up with a coherent, better solution across both the areas of law. And conversely, while there might be some counter arguments, again, let's just go back to what's been said this afternoon and think about what's at stake. We've had a lot of discussion about whether the current law is coherent or certain or predictable, and I think it really isn't. And we can see that if we look at the number of appeals there have been on this topic and the difficulty that there's been with guilty pleas in cases like McNally and Jeter. And then just to bring us full circle and to refer back to something Peter said right at the beginning, let's not forget that at the heart of Lawrance, we've got a victim who has not now, from the criminal law, received sufficient protection for her sexual or reproductive autonomy, or indeed for her general physical health in terms of STIs and so on. So I do think this is an area in which we both can and we should do a lot better than we currently are. So thank you very much.
Rebecca, thank you very much. We've got lots of questions. I'm going to just start off by asking whether or not we can focus on that first half of the panelists' papers, really, the first few papers. Can we make the criminal law, the common law, under the interpretations of the Sexual Offences Act work? Is the solution, as Joe Miles has postulated before now, to go back and to say that Section 76 is an exhaustive definition of those deceptions that will vitiate consent? Matt Gibson asks a similar question: how should we define deception in these cases? So is it possible for us to draw a line? And I'm going to invite panel members to voice their opinions on that. And then I've got a couple of specific questions which Mark's paper has prompted. So I'll come back to those. But just generally, it seems fair to start with you, Peter. Given that this is a well-worn debate between yourself and Joe Miles and others, Section 76, should it be exhaustive in its interpretation, or is that just such a strained statutory interpretation that it won't wash?
Well, I take the view that 76 is very narrow, as it has to be, because it's an irrebuttable presumption, and it only covers a very limited number of cases. And so it can't possibly restrict Section 74. And the presumptions, and this includes Section 75 as well, are there to buttress Section 74, not to limit it. And they're simply a way of proving the particular offences. It's proving absence of consent. So I don't think we can derive much assistance from Section 76. And so we have a gap which needs to be covered. As the physical integrity and personal autonomy is not protected enough at the moment. One final point, if I may, quickly, is the interesting Section 74, Section 4 point, that what if a woman lies as to whether she's taken the pill or not, a point that was taken by the Lord Chief Justice in Lawrance. But is that actually right? Because if the law is to protect the physical integrity of the complainant, then of course in that instance, the male's physical integrity wouldn't be compromised.
Yeah, very good point. Any other views on Section 76? Rachel, I suspect you have, yes.
Thanks, David. I agree with what Peter's just said, and the only thing I'd add to it is that it seems to me that there's nothing in EWCA that necessarily would result in a fair expression of the pre-2003 common law position being deception as to a sort of deceptive impersonation of a sexual partner vitiates consent. It seems to me that it's entirely consistent with EWCA to say, well, there'd be no need to direct a jury in terms of deception. Simply mistaking the person you're having sex with for your previous sexual partner would vitiate consent under the old common law. Now, if that's the case, I think it's very difficult to suggest that that kind of mistake case would fall within Section 76. And so if you take that kind of, the sort of Miles position, that Section 76 covers all of the ground, then you're left with a post-2003 position, which is in fact narrower than the common law, and very difficult to justify if you think actually what EWCA and Section 76 to be represent is this idea that consent has to be given to the person you're having sex with, not some other third party. So that's the only thing I'd add to the Section 76 point. On deception and mistake, I mean, I tend to be in a minority in that I think we can and should distinguish between deception and unilateral mistake when it comes to consent validity. I think there's a reading of sexual autonomy which is entirely consistent with that distinction, but I won't try and explain why I think that that's the case in about 30 seconds, because I don't think I'd be able to do the point justice. What I would say in terms of the reasoning of the court is this: I think the Court of Appeal and the High Court are really struggling to understand what the relevant distinction is. Now, if you go back to Lord Justice Latham's decision in B, what Lord Justice Latham essentially says is there's no way you can spell out from mere non-disclosure of HIV status and implied deception that the defendant is HIV negative. Now, fast forward to McNally, Monica and Lawrence, and you see the court saying, well, the distinction here is between active deception, these sort of express deceptions about HIV status, and non-disclosure, whereas I think actually the distinction is one of deception, including active deception, implied deception, much more kind of subtle forms of deception, and mere non-disclosure, a sort of unilateral mistake. And we distinguish in that way elsewhere in the law, both criminal and civil. So for the court in Monica to suggest that, well, this is a hopeless distinction because we can't possibly seek to distinguish between active deceptions and more subtle forms of deception, somewhat misses the point, because that's not, if you were to draw a sort of, if you were to take non-disclosures out of this area of the law, it wouldn't be passive deceptions, implied deceptions you're trying to square away, it would be those mere non-disclosures. And indeed, that's the sort of way in which Section 3 of the Fraud Act works, right? So I think there's again a problem with the reasoning there.
Okay, can I turn to a couple of questions that have come in specifically in relation to Mark's innovative approach? I'm not going to go through them all and read them all out, but effectively they fall into two camps. Questions about the extent of that proposal and whether or not it means that any deceit whatsoever vitiates consent, and whether there is any restriction there. And then secondly, a more practical question about the ways in which the cases would ever be proved. How would it be possible to prove cerebral decision-making without the complainant having expressed it directly? Mark?
Yeah, good, thanks. So as to the first question, that's a bullet I'm willing to bite. If sexual autonomy is really that important, then I get to choose the conditions under which I will have sex. So if I want to choose, for instance, I think the question mentioned something about the wigs not being bald. Yeah, if that's a deal breaker for me, then that's a deal breaker for me. The point of giving me autonomy is that I get to decide. The thing is, I'm not going to, not every prejudice that I have is going to affect my consent. I have to actually actively advert to it and make a cerebral decision to make that relevant to my choice on this occasion on the proposal that I'm making, which of course leads to the next question. How would you ever prove that? And I take that point. It's going to be very difficult to prove that in most circumstances. I have given one example in the blog post of how it might happen. So for instance, let's take Lawrence's facts. And let's just imagine that the conversation about vasectomy just before the sexual intercourse didn't actually happen between the two parties, but the complainant spoke to her friend on the phone saying, well, I'm not going to insist on a condom on this occasion because he said that he's had the vasectomy, and I believe that. You can have the assertion being made to a third party rather than to the defendant. And in terms of mens rea, you could perhaps prove that if Lawrence overheard the conversation and texted his friend saying, I'm in luck here, or something to that effect. So I realize that these are very strange cases, but the point that I'm trying to make is the rules of what we can prove or what we cannot prove should not change the substantive rule that we have in law. The substantive rule needs to follow principle. And I'm fully cognizant of the fact that we will not be able to necessarily prove all these matters. That's why we have a burden of proof that says, well, better that 10 guilty go free than 1 innocent be locked up.
Okay, do any of the other panelists want to come in on any of that? Nigel, I was looking to you to see whether or not you thought that the proposal would work for the Crown.
Well, I mean, clearly the issue of proof is a difficult one. And not only that, there would need to be extensive investigations by the police and then a review and then a decision. And if you can't prove it, going through all that, and then the case wouldn't just get very far. So there are sort of practical issues about A, the investigation, and B, putting people through it when maybe initially it looks a complete no-hoper from the start. Although I accept that there may be cases where a proper investigation should take place and a consideration of prosecution to be considered.
Okay, thank you. We've got another question that's a more general question from John Riley, who's got vast experience in this area. Really boils down to whether or not we think we can have a list. Is it possible to draw up a list of critical instances where consent is compromised? If we can't identify a single one-size-fits-all principle in the way that Monica sought to do, can we instead identify particular factors, particular characteristics which will always vitiate consent? Anybody? Rebecca, your...
Yeah, so I mean, I mentioned in the talk, if we aren't able to completely rethink this and completely look at legislation, then I think we can do better than we currently are. And I'd say, I think if it does go to the Supreme Court, there are categories that could be drawn. It wouldn't necessarily even be necessary, I don't think, for the court to draw all of those up front. But as it deals with a particular case, it could say, right, you know, as far as I'm concerned, this falls into this particular category. Here are the ambits of that category, such that any future court can then understand the contents of that category and what would fall into it and what wouldn't. And here's my normative justification for why I think that's covered. And that could happen on a sort of more incremental basis, but in a much more coherent fashion than we've got so far. if I was going to sort of start my starting bids, I've said before, I think should be some kind of physical difference case, like the 4 cases that are in the slide, FB, Assange and Lawrance. But I think we could also potentially think about legal qualification cases, particularly if we're thinking of non-sexual offences as well. So, you know, I claim to be your dentist and treat you, or I claim to be your doctor and treat you, or something like that. We might think of that as a category as well. But I think a court could do that. They could say, you know, I'm creating a category and this is the definition of that category in such a way that a future court could understand. But I just think, you know, that ultimately we'd be better at doing something even more radical than that.
Any of the other panelists want to come in on that? Yes, Rachel, please do.
As I say, as a sort of compromise position, an uneasy but necessary compromise position, I think that sounds probably about the best we're going to get. The real difficulty as a matter of principle with that sort of solution, though, comes back to what Mark was saying before about the subjectivity of sexual autonomy and integrity. And if something genuinely is a deal breaker to you and you're deceived about it, it's I think it's very difficult to argue that your sexual autonomy hasn't been violated. Part of the difficulty, I think, with the courts and frankly a lot of commentators' approaches in this area, if I may, is this idea that we're consistently looking for deceptions that are serious enough or important enough or bad enough to vitiate consent, takes us further and further, keeps us far away from this idea of sexual autonomy as the motivating principle or concern in this area of the law. Where I would probably come apart from Mark and be unwilling to bite certain bullets, not all of them, but certain bullets, is I think sometimes we have very good reasons not to criminalize certain forms of deceptions, even if they induce consent. And I think one example, and you know, this is, I'm not going to go further than the intuition, but I suspect that many people would think it's inappropriate to use the criminal law to prosecute a 14-year-old who lies about being 16 to their sexual partner. Now, certainly that's a kind of deception which operates for Mark at a cerebral level of the decision-making of the 16-year-old who says, how old are you, before they have sex. And it's certainly a deception which I would view as infringing the sexual autonomy of the older party. But do we think it's appropriate to criminalize the 14-year-old for rape, sexual assault by penetration? Well, I would say no. And if you agree with me on that, then I think the bullet you really have to bite is there are some deceptions which do infringe sexual autonomy, but which should not be criminalized. Figuring out what those categories of deception are is, I think, much more difficult than trying to say, well, what do we think are genuinely serious enough to warrant consent vitiation? That's the
Mark,
real problem, I think.
I'm predicting, Mark, that you want to come back on that.
Just very briefly, I mean, I think Rachel's right about that case, but I think it might just point to a problem with other parts of the law rather than with our understanding of consent, about what we criminalize. And besides, having a positive reason to criminalize something isn't necessarily the same as having a conclusive reason to criminalize something. So we might say, well, there are other considerations that matter. I did want to briefly add something about the categories question. I think that on the view that I described, the only one category that you can certainly say this definitely means that there is no consent is the Flattery and Williams kind of cases, where the complainant just doesn't even realize that what's happening is a sexual act, because on my view, they cannot exercise sexual autonomy to grant or withhold consent if they don't know that it's sexual autonomy that's being called into question.
Okay. I'm going to go to one of the questions that was posed before we started by John McLidden, Queen's Counsel, which is, again, I'm not going to read out the whole question. Effectively, he's suggesting that maybe the criminal laws are lost cause on this, and perhaps the solution is for incremental headway to be made by victims using civil claims. Anybody have a view as to whether or not that will be a more effective way of some principled line drawing? Or are we better focusing on primary legislation in the criminal sector? Nobody's going to offer a view. I thought that was quite a radical suggestion, but the wrong audience of criminal practitioners, of criminal experts, I suppose.
I can have a quick stab at it. I think I do agree that the criminal law should probably be one of, if not the last resort for changing behavior. Not just because it's such a heavy-handed instrument, but also because there are other things that will probably work better. And one worry with this suggestion is what it does for the rights of the complainant in terms of anonymity, in terms of having the state's resources to investigate for you. But maybe those problems can be solved. But I'm sympathetic to the idea of saying the criminal law need not be the only solution.
Okay, I'm conscious of the time. I just want to fit in one or two other questions. We've dealt with a couple of the questions that were posed before the session and that have been reiterated about the potential value of reintroducing a Section 3 offence. I think, and there are some other questions that have come in relation to Mark's proposal, which I leave Mark to follow up on. I want to just ask whether or not you think that this is something which can be solved by comparative analysis. One of the things which I'm sure the Law Commission would do if it was to be handed this as a reform project is to engage in a bit of legal tourism to see what's been going on around the globe. And Rebecca, you mentioned, I think, in one of the discussion points, some of the Canadian models. Does anybody have a view that there is a jurisdiction in the world that has got this right, that has struck precisely the right balance? Lots of head shaking. Nobody's going to suggest any approach that's infinitely better than ours. Well, that's at least a positive comment, I suppose, on the English position, if nothing else.
What I might say, if I may, is that I think certainly the jurisdictions that I've spent time looking into all approach the problem from the same direction. What deceptions are bad enough, serious enough, significant enough to warrant consent vitiation, rather than starting from the reverse default position and looking for those we ought to take outside the scope of the criminal law. And that's why I think all of the jurisdictions are getting the answer wrong, including our own. Of course, the Canadian model is fairly similar to my preferred, albeit compromised, position for within the current legislative framework. But even there, the Canadians are having some difficulty, and there's been recent appellate case law on some of the difficulties, the conceptual difficulties and nuances of that position. So no one's having an easy time of it.
That's reassuring in some sense. There are a couple of questions for Rebecca, and then I'm going to bring things to a close, about the challenges that might be faced by a model drawing such an analogy with fraud and with the Fraud Act when there was such heavy criticism of the Fraud Act. And won't the same criticisms be levelled at this model if it was adopted in relation to sexual offending?
So I think there are obviously criticisms of the Fraud Act, not least the fact that it is so far only behavioural. I should be clear about that when I'm suggesting we analogize to fraud, I'm thinking of fraud broadly in both its previous and its current form. So not necessarily adopting the kind of inchoate/behavioural model of it. And we might well want to go back to situations in which actual property was obtained by deception and look at those instead as our analogy. It was more to the sort of the idea of a broad analogy with fraud as a concept and as one of a series of concepts of different kinds of property offences that I was really thinking of. And certainly if we think, but again, going back to the point I made before about having the two areas in line with each other, if we think there are problems in the existing fraud offences and we look at those alongside the sex offences, we can solve those problems simultaneously.
Okay, anybody else want to come in on any comment in Rebecca's proposal for the legislation? I think at that point, I should perhaps draw things to a close. I'm conscious of the fact that most of the panelists look like they're melting, and I'm sure that's true of those of you who've got your cameras off as well. Just like to say thank you very much to the panelists who volunteered with very little pressure at short notice to present, and everybody produced their slides and made everything such an accessible session, such an accessible event. Thank you very much. Thank you for all of you sitting in front of your screens on these unprecedentedly hot days. And thank you very much to Lisa, who has been fantastically efficient in ensuring that this all ran so smoothly. Lots of behind the scenes organising of the 6 panelists, myself, but also of all of the Eventbrite and so on. So thank you very much to Lisa. Before everybody logs off, can I just encourage you to keep an eye on the UCL Centre's website. We hope to be running some similar events in the autumn term in relation to topics such as the minimum age of criminal responsibility and so on. So if you keep an eye on the website, you will see those advertised in good time. Sorry we didn't get through all of the questions. There were quite a few questions coming in for individual speakers, but I think that's given us a good flavour of the types of problems and types of solutions in this very knotty area. So thank you once again, and look forward to seeing some of you at a UCL event live in person before too long.